Good day, everyone. Welcome again to another lecture on civil procedure. Our topic for today is manner of making allegations in the pleadings. How do you allege your cause of action, your claim, your defense, your counterclaims in a pleading? Now, Section 1 of Rule 8, okay, tells us or instructs us how to make allegations in the pleadings. As a general rule, every pleading shall contain in a methodical and logical form a plain, concise, and direct statement of the ultimate facts, including the evidence on which the party pleading relies for his or her claim or defense. So, underline the word methodical. So when you say methodical, it means it is arranged, systematically. Okay? It is numbered. Okay? For the purpose of ease in identification. The statements of the cause of action or the defense must be plain, meaning simple language. It must be concise. It must not be too lengthy. Okay, as if you're writing a novel. It must be at the stated in a summarized form. Okay? Direct statement of the ultimate facts. Only the ultimate facts. Okay? Including the evidence. Now, the law or the rules require the pleader to state not only the basic allegations of the cause of action, but also the evidence. That is the reason why under the new rules, it is now required that the pleader must attach to the pleading, especially if it is an initial one, like the complaint, the judicial affidavit of the witnesses. Okay? A pleading should, if a cause of action or defense relied on is based on law, the pertinent provisions of the law and their applicability to him shall be clearly and concisely stated. Okay, so the contents of a pleading must, okay, first is the ultimate facts of the cause of action or the defense, the evidence, okay, which consists of testimonial, object, and documentary evidence, and the law and relied upon in support of your position or claim. General conclusions of law stating that the contract is void, voidable, illegal, or ultra vires or against public policy without stating the facts showing its invalidity are not sufficient, and the same may be dismissed on the ground of failure to state a cause of action. Okay, so what is failure to state a cause of action? It means that the basis of the allegations in the pleadings and hypothetically admitting the truth thereof, the court should not grant the relief prayed for because the allegations in the pleading, inclusive of its attachments, is insufficient to justify the grant. So in other words, there is a failure to state the cause of action in the pleading itself. Okay? If you must also state the reason or the justification why the said contract is void. It is not sufficient to just state that it is void without invoking or stating the justification why the said contract became void. You must remember that failure to state a cause of action is based solely on the pleadings filed by the parties without considering any extraneous evidence. The opposing party must raise this as an affirmative defense, praying for the dismissal of the action in the earliest possible time. Okay, we have the case of Santos versus Grant. Well, in this case, Santos filed a complaint for annulment of sale and revocation of title against the respondent Gran. Now, the basis for the complaint for annulment of sale is that the document relied upon, the deed of sale is void or voidable. So, however, Gran moved to dismiss the complaint on the ground that it failed to state a cause of action, as the void and voidable documents sought to be nullified were not properly identified, nor the substance set forth. The RTC granted Gran's motion and dismissed the amended complaint. Okay, the deed of sale, the CA sustained the dismissal because the deed of sale sought to be annulled was not attached to the amended complaint. So what do you mean by failure to state a cause of action? In the case of Gran, this is a matter of insufficiency of the pleading. Failure to state a cause of action is different from failure to prove a cause of action. The remedy of the first is to move for the dismissal of the pleading, while the remedy in the second is to demur to evidence. So there is a difference between failure to state a cause of action and lack of cause of action. If you're moving to dismiss on the ground of failure to state a cause of action, you are relying solely on the pleading, that admitting all the allegations of the pleadings as true. Okay, still the plaintiff is not entitled to the relief prayed for. Okay, in the case of Gran, it was because the deed of sale that was relied upon, okay, for the nullification of the deed, okay, was not attached to the pleading. Okay, so in that case, under our rules today, failure to state a cause of action is no longer a ground for a motion to dismiss. What you do is either you allege it as one of your affirmative defenses in your answer and move that a summary hearing be held for the purpose of determining whether or not the plaintiff indeed failed to state a cause of action, or move for summary judgment or judgment on the pleadings later. Okay. On the other hand, lack of cause of action is a matter of evidence. So you don't only rely on the pleading itself, but you also consider the evidence presented by the plaintiff. If based on the evidence presented by the plaintiff, okay, there was lack of cause of action, he failed to sufficiently substantiate, okay, the cause of action, his cause of action, then it may be a basis for a demurrer to evidence that standing alone, the evidence presented by the plaintiff would not be sufficient to grant the relief prayed for. Okay. The plaintiff's cause of action should not merely be stated, but importantly, the statement thereof should be sufficient. That is why the elementary test in a motion to dismiss on such ground is whether or not the complaint alleges facts which, if true, would justify the relief demanded. Since the inquiry is into the sufficiency, not the veracity of the material allegations, it follows that the analysis should be confined to the four corners of the complaint and no other. So, in determining whether or not the complaint failed to state a cause of action, you confine yourself exclusively to the four corners of the complaint. You don't consider extraneous matters. The allegations in the answer cannot be considered. The complaint standing by itself is hypothetically admitted. However, even if all the allegations in the complaint are true, okay, still the pleading failed to state a cause of action. Nothing in the pleading, however, indicates that the former had become any of the properties of the owner. This leads to the logical conclusion that her right to the properties in question, at least through the manner in which it was alleged in the amended complaint, remains unfounded. While the facts alleged in the complaint are hypothetically admitted, it must be remembered that the hypothetical admission extends only to the relevant and material facts well pleaded in the complaint, as well as to inferences fairly deductible therefrom. Clearly, the claim that the sale was effected through voidable and void documents partakes merely of a conclusion of law that is not supported by any averment of circumstances that will show why or how such conclusion was arrived at. What these voidable and void documents are were not properly stated or identified. In other words, if you are making a general conclusion of law that the basis, okay, for the transfer of title, for example, to your name is based on void and voidable documents, you must state with particularity how they became void and voidable. Okay, you must state the circumstances under which, okay, it became void or voidable. By merely stating a legal conclusion, the amended complaint presented no sufficient allegation upon which the court could grant the relief petitioner prayed for. The pleading should be dismissed on the ground of failure to state a cause of action. So, considering that you now know what matters or how to make allegations in the pleading, you state the ultimate facts in a concise, logical, methodical manner. You state the law, jurisprudence, legal basis, which will support your contention. Okay. What are the facts that must be alleged in a pleading? The following must be alleged in the pleading. First, conditions precedent. Okay, it is a general averment of the performance or occurrence of all conditions precedent shall be sufficient. An example of this would be in all disputes or cases involving members of the same family, it is required to state in the pleading that efforts towards amicable settlement were exerted, but the same has failed. Okay, so the complaint must state that. Okay, otherwise it can be dismissed. Okay, for failure to comply with a condition precedent. Okay, another is capacity. Fact showing the capacity of a party to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, or the legal existence of an organized association of persons that is made a party must be averred. So in case of a corporation, you must state whether it is a domestic corporation organized under the laws of the Philippines, or it is a foreign corporation doing business in the Philippines. Okay? In the case of natural persons, okay, you must state also the capacity of that person, showing that he is of legal age and therefore had the requisite capacity to be sued. Okay? Fraud, another fact that must be alleged, fraud, mistake, or and condition of the mind. In all averments of fraud, mistake, the circumstances constituting fraud or mistake must be stated with particularity. Remember, fraud must be proved by clear and convincing evidence. So in your pleading, if there is an allegation of fraud, you must state with particular definiteness, okay, the facts constituting the fraud. Mere allegation, a general allegation of fraud would not be sufficient. You must state with particularity the circumstances under which there was fraud. The same is true with respect to mistake. Malice, intent, knowledge, or other conditions of the mind of the person may be averred generally. Okay, but with respect to fraud or mistake, it must be with particularity. Okay, another fact that must be alleged, judgment. Okay, if you are basing your cause of action or your defense in a judgment, okay, it is necessary that you append the judgment relied upon in your pleading, or you copy a portion of the said judgment. In a pleading, a judgment or decision of a domestic or foreign court, it is sufficient to aver the judgment or decision without setting forth matters showing jurisdiction to render it. An authenticated copy of the judgment shall be attached to the pleading. If an action is based on a document, if an action or defense is based on a document, upon a written instrument or document, the substance of such instrument shall be set forth in the pleading, and the original or a copy thereof shall be attached to the pleading as an exhibit, which shall be deemed part of the pleading. So, for example, if you are relying on a deed of sale, okay, you attach the deed of sale to the pleading and you indicate or quote a portion thereof in the body of the pleading. Okay, and lastly, official document or act. In pleading an official document or official act, it is sufficient to aver that the document was issued or the act was done in compliance with law. Okay, we have the case of Alabang Development versus Alabang Hills Village Association. Okay, ADC filed a complaint for injunction against Alabang Hills on the ground that Alabang Hills started the construction of a multipurpose hall on one of the parcels of land still owned by ADC or Alabang Development. Alabang Hills claimed that the latter had no legal capacity to sue, since its existence as a registered corporate entity was revoked by the SEC. So we are referring here to capacity, which is one of the matters which must be alleged in the pleading. Lack of legal capacity to sue means that the plaintiff is not in the exercise of his civil rights or does not have the necessary qualification to appear in the case, or does not have the character or representation that he claims on account of minority, insanity, incompetence, lack of juridical personality, or any other general disqualifications. In this case, there is no dispute that petitioner's corporate registration was revoked. Okay, it had 3 years to prosecute or defend any suit by or against it. The subject suit was filed, however, more than 3 years after the revocation of the SEC registration. Petitioner filed its complaint not only after its corporate existence was terminated, but also beyond the 3-year period. It is clear that at the time of the filing of the complaint, petitioner lacks the capacity to sue as a corporation. So it is dismissible. Columbia Pictures versus CA. Okay. In this case, although a foreign corporation is without license to transact business in the Philippines, it does not follow that it has no capacity to bring an action. Such license is not necessary if it is not engaged in business in the Philippines. So in the case of Columbia Pictures, the court distinguished between lack of capacity to sue and lack of personality to sue. The term lack of capacity to sue should not be confused with the term lack of personality to sue. While the former refers to a plaintiff's general disability to sue, such as on account of minority, insanity, incompetence, lack of juridical personality, the latter refers to the fact that the plaintiff is not the real party in interest. Okay, the first can be a ground for a motion to dismiss on the ground of lack of legal capacity, whereas the second can be used as a ground for a motion to dismiss based on the fact that the complaint evidently states no cause of action. So the ground available for barring recourse to our courts by an unlicensed foreign corporation doing or transacting business in the Philippines should properly be lack of capacity to sue and not lack of personality to sue. Cañete versus Genuino Ice Company. In this case, petitioners filed a complaint for cancellation of title to property on the ground that the titles are spurious, fictitious, and were issued under mysterious circumstances. Respondent moved to dismiss on the ground that based on the allegations of the complaint, no relief as a matter of law can be granted. So the basic rules of proper pleading require that every pleading must contain in a methodical and logical form plain, concise, and direct statement of the ultimate facts. The circumstances, however, in this case, constituting fraud or mistake must be stated with particularity. However, in all averments of fraud or mistake, the circumstances constituting fraud must be stated with particularity. In this case, while there are allegations of fraud, the same are not particular enough to bring the controversy within the sex jurisdiction. The said allegations are not statements of ultimate facts but are mere conclusions of law. General allegations that a contract is valid or legal, just, fair, and reasonable are mere conclusions of law. Likewise, allegations that a contract is void, voidable, invalid, illegal, ultra vires, or against public policy without stating facts showing its invalidity are mere conclusions of law. What do you mean by ultimate facts? It means the essential facts constituting the plaintiff's cause of action, or such facts which are essential that they cannot be stricken out without leaving the statement of the cause of action inadequate. Petitioner's second amended complaint betrays no more than an incomplete narration of facts unsupported by documentary exhibits. The allegations partake of conclusions of law, unsupported by particular averments of circumstances that will show why such inferences were arrived at. It is replete with sweeping generalizations and inferences derived from facts that are not found therein. While there are allegations of fraud upon a claim that the titles were fictitious, spurious, and obtained under mysterious circumstances, the same are not specific to bring the controversy within the trial court's jurisdiction. Again, if you're alleging fraud, okay, you must state with particularity the circumstances constituting the fraud. In the absence of specific averments, the complaint is defective, for it presents no basis upon which the court should act or for the defendant to meet it with an intelligent answer. Manner of denying allegations. So, we're already through with manner of making allegations. Now, how do you deny the allegations? Specifically in the answer. When an action or defense is founded upon a written instrument or attached to the corresponding pleading, the genuineness and due execution of the instrument shall be deemed admitted unless the adverse party under oath specifically denies them and sets forth what he or she claims to be the facts. But the requirement of an oath does not apply when the adverse party does not appear to be a party to the instrument or when compliance with an order for an inspection of the original instrument is refused. That is the reason why an answer is always verified. One of the reasons why an answer is always verified is because it contains ordinarily denial of a written instrument which is alleged in the complaint. Okay? And if you have a written instrument which is the basis of a cause of action in the complaint, okay, you must deny under oath the genuineness and due execution of the said document. Okay? And you must also, aside from denying it, you must also set forth or allege what you claim to be the facts. Okay. Now, what is a specific denial? How do you specifically deny? Does the insertion of the word specific on the denial make it a specific denial? Section 10, Rule 9 states that a defendant, Rule 8 rather, a defendant must specify each material allegation of fact, the truth of which he does not admit, whenever practicable shall set forth the substance of the matters upon which he relies to support his denial. Okay, so that is the general rule on denial. You deny and you state what you claim to be the facts, your version of the story. Okay. When a defendant desires to deny only a part of an averment, he shall specify so much of it which is true and shall deny only the remainder. That is what is called a partial denial. So you partially admit portion of the statement and deny the rest. Where a defendant is without knowledge or information sufficient to form a belief as to the truth of a material averment, he shall state, and this shall have the effect of a denial. Okay. With respect to matters which you have no personal knowledge or which is all only within the knowledge of the other party, you can make a disavowal of knowledge. Okay? And that would be sufficient and considered as a specific denial. Okay. Allegations not specifically denied are deemed admitted. Material averments in a pleading, asserting a claim other than those as to the amount of unliquidated damages shall be deemed admitted when not specifically denied. Okay, so there is, if you're answering a pleading, there is a duty on your part to specifically deny each and every allegation by availing of how to make specific denials under Section 10 of Rule 8. Fernando Medical versus WUP. So this is a complaint for a sum of money. Now, the respondent moved to dismiss the complaint on the ground of lack of jurisdiction, proper venue, litis pendentia, forum shopping. The RTC denied the motion to dismiss. Now, the petitioner filed a motion for judgment based on the pleadings on the ground that the respondent has admitted the material allegations of the complaint and thus did not tender an issue. Respondent opposed the motion, arguing that it had specifically denied the material allegations in the complaint. The respondent tendered an issue as to the amount of the balance due to petitioner under the subject contracts. In other words, the question of the respondent is to the amount of the balance due. Okay. According to the Supreme Court, the answer admitted the material allegations of the ultimate facts in the complaint only when it expressly confesses the truth of such allegations, but also when it omits to deal with them at all. Okay, there are three modes of denial, as we have previously discussed. Specific denial, setting forth what you claim to be the facts, partial denial, and disavowal of knowledge. So in the case of a written instrument or document, um, otherwise known as an actionable document, the pleader is required to set forth the substance of such instrument in the pleading and to attach the original to the pleading as an exhibit. The adverse party is deemed to admit the genuineness and due execution of the actionable document unless he specifically denies them under oath and sets forth what he claims to be the facts. But the requirement of an oath does not apply when the adverse party does not appear to be a party to the instrument. The admission of the various agreements significantly admitted the petitioner's complaint. The petitioner's cause of action was based on the February 11, 2009 agreement, which was the actionable document in the case. Upon the express admission of the genuineness and due execution of the February 11, 2009 agreement, judgment on the pleadings became proper. There is no need for proof of execution and authenticity with respect to documents, the genuineness and due execution of which are admitted by the adverse party. The court believes that judgment may be had solely on the document and there is no need to present receipts and other documents to prove the claimed indebtedness. Indeed, the effect of admission is such that a prima facie case is made for the plaintiff which dispenses with the necessity of evidence on his part and entitles him to a judgment on the pleadings unless a special defense of new matter such as payment is interposed by the defendant. The respondent denied paragraphs 6, 7, and 8 for lack of knowledge sufficient to form a belief as to the truth or falsity thereof, inasmuch as the alleged transactions were undertaken during the term of office of the past officers of Wesleyan. Was the manner of denial effective as a specific denial? Considering that paragraph 6, 7, and 8 averred matters that the respondent should know or could have easily known, the answer did not specifically deny such material averments. It is settled that denials based on lack of knowledge or information of matters clearly known to the pleader or ought to be known to it or could have easily been known by it are insufficient and constitute ineffective or sham denials. So with respect to the case of Fernando, teaches us that with respect to denials by disavowal of knowledge, it is only available if clearly you have no knowledge of the facts pleaded by the plaintiff. If the facts pleaded are matters which you should know or could have known, okay, or ought to have known, then the said disavowal of knowledge is not available, okay, as a way of denying the allegations in the pleading. You must make a specific denial by denying it and stating what you claim to be the facts. Otherwise, if you just make a disavowal of knowledge, it will be considered as a sham denial. Okay, we now move to the case of Gotong Electrical versus BPI family. In this case, respondent filed a complaint against Gotong for the payment of a loan obligation. In the answer of Gotong, it stated that they specifically deny the allegations in the complaint. They denied the execution of the loan agreement, the promissory note, and the CSA for being self-serving and pure conclusions. A reading of the answer shows that the petitioners failed to specifically deny the execution of the credit agreement, promissory note, and CSA. It does not constitute an effective specific denial. A denial is not specific simply because it is qualified by the use of the word specifically. Neither does it become so by the simple expedient of coupling the same with a broad conclusion of law that the allegations contested are self-serving or intended to suit plaintiff's purposes. To constitute specific denial, there must be a denial, and then you must set forth or state what you claim to be the facts. Okay? Inserting the word specifically, self-serving, to suit the plaintiff's purposes, would not convert the denial to a specific one. Okay, the defendant must declare under oath that he did not sign the document or that it is otherwise false or fabricated. With the said pleading failing to comply with the specific denial under oath requirement, the proper conclusion is that the petitioners had impliedly admitted the due execution and genuineness of the documents. Failure to deny the genuineness and due execution of an actionable document does not preclude a party from arguing against it by evidence of fraud, mistake, compromise, payment, statute of limitations, estoppel, and want of consideration, nor bar a party from raising said defense in his answer. Okay, we now go to alternative causes of action or affirmative defenses. Okay, in the pleading, a party may set forth two or more statements of a claim or defense alternatively or hypothetically, either in one cause of action or defense or in separate causes of actions or defenses. When two or more statements are made in the alternative and one of them, if made independently, would be sufficient, the pleading is not made insufficient by the insufficiency of one or more of the alternative statements. Okay. Now we go to affirmative defenses. Affirmative defenses, okay, is what makes the answer a complaint in itself. Okay? Because in affirmative defenses, even the pleader, uh, even hypothetically admitting that the claim of the plaintiff is true, it would not prosper because of the affirmative defenses that the pleader is invoking. What are these affirmative defenses? A defendant shall raise his affirmative defense in his answer, which shall be limited to the following grounds: that the court has no jurisdiction over the person of the defending party. So when you say no jurisdiction over the person of the defendant party, that means invalid or ineffective service of summons. That venue is improperly laid, that the plaintiff has no legal capacity to sue, that the pleading asserting the claim states no cause of action, that a condition preceded for filing the claim has not been complied with, and failure to raise the affirmative defenses shall constitute, at the earliest opportunity, shall constitute a waiver thereof. So if you have these affirmative defenses, okay, then you can move, okay, for the court to have the same be heard, okay, only for the purpose of that affirmative defense. There is an obligation to raise this affirmative defense at the earliest possible time. Otherwise, they are considered waived. The court shall motu proprio resolve the above affirmative defenses within 1 month from the filing of the answer. As to the other affirmative defenses, the court may conduct a summary hearing within 15 calendar days from the filing of the answer. Such affirmative defense shall be resolved by the court also within 1 month from the termination of the summary hearing. Okay. Striking out of a pleading upon motion made by a party before responding to a pleading, or if no responsive pleading is permitted by the rules, upon motion made by a party within 20 calendar days after the service of the pleading, upon him or upon the court's initiative, the court may order any pleading to be stricken out, or that any sham, false, redundant, immaterial, impertinent, or scandalous matter be stricken out therefrom. Okay, so that is all for Rule 8. Thank you for listening and don't forget to subscribe.